Welcome to Property Law 101. I'm Sara Bronin, and I created the series to help you understand the basics of property law. So we cover 4 fundamental questions in this series, and today we are talking about the third question, using property. Specifically, we're talking about our ability to use property for residential purposes or for residential housing. You may have heard the phrase exclusionary zoning. So if you've heard it before, you might not know exactly what it means. What it refers to is zoning that has the effect of excluding certain groups, even if the zoning laws themselves don't specifically exclude those particular groups. So exclusionary zoning is the subject of this video. In the video on the pros and cons of zoning, we mentioned the 1917 case, Buchanan versus Worley, which considered the zoning ordinance of Louisville, Kentucky. That ordinance was called an ordinance to prevent conflict and ill feeling between the white and colored races. That was its title. It banned Black residents from moving into areas that were predominantly white and vice versa. The Supreme Court in Buchanan struck down this kind of racially explicit zoning on 14th Amendment grounds. In doing so, the court said that the effect of the ordinance, quote, was to destroy the right of the individual to acquire, enjoy, and dispose of his property. This was both an observation about freedom of contract and due process. So no longer can communities explicitly segregate on the basis of race, like you see in the Louisville Ordinance. So our zoning laws today are not explicit in zoning by race, but with exclusionary zoning, we see zoning that has the effect of excluding certain groups. Again, even if the zoning laws themselves don't specifically exclude them or address them or call them out by name as it did in Louisville. Why do we care about residential segregation? Segregation prevents barriers to opportunity and mobility. It hurts our economy. It leads to disparate educational outcomes. It actually also contributes to poor health for those living in highly segregated areas. So there are a lot of consequences to the kind of segregation our land use laws institute. So what does exclusionary zoning mean? What form does it come in? So sometimes you have exclusions or prohibitions on mobile homes and multifamily housing. This type of housing will, statistically speaking, bring people into a community who are low income. Some people also believe that multifamily housing brings too many kids into the school system, even though studies have shown that on a per unit basis, there are fewer kids in units of multifamily housing than single family housing. Other people mistakenly believe that multifamily housing actually reduces the prices of single family housing. In fact, studies have shown that the opposite is true. Minimum lot size zoning is another type of exclusionary zoning. A zoning ordinance might say that you have to have an acre of land to put a house in a particular neighborhood. This kind of zoning raises the price of housing by ensuring that there is less of it because it's constrained by the amount of land in a jurisdiction. Minimum lot sizes make it hard for people to carve out small lots and more affordable lots. In Connecticut, the majority of residential zoning has high minimum lot sizes. Some ordinary people think that this type of zoning protects their home values. They think that their local laws have positive effects on these values. The reality, though, as I said before, is that this type of zoning hurts not only wealthy communities, but poor ones too. In another video, we discuss how it is that states give local governments the authority to zone through enabling acts that specify what local governments can and can't do. It might be interesting here just to note a couple of states that have tried to deal with exclusionary zoning. In New Jersey, there's a case in the Supreme Court decided in 1975 in the New Jersey Supreme Court called Mount Laurel. In the case, the plaintiff sued a town whose zoning allowed only single-family dwellings and some very limited planned unit developments for small-scale multifamily housing. Among other things, the planned unit development provisions cap the number at two of children who were living in any one multifamily unit. The court said that this was unacceptable and said that the town had to provide its fair share of multifamily housing. Since that decision and several others, New Jersey has actually set up a state administrative agency whose primary job is to implement the Mount Laurel decision. So that's New Jersey. Connecticut, another state, has a law called 8-30G. It holds that where there are in communities with homes where less than 10% of the stock is designated affordable under state law, developers can sue in court against those towns to get the local governments to approve their projects when those projects will provide affordable housing. So this framework, the builder's remedy it's called, requires developers with the money, time, and energy to sue. Should mention that Massachusetts's Anti-SNOB Act is similar to Connecticut, but it allows developers to appeal to a state review board rather than courts. Right now, there's a flurry of activity in state legislatures across the country, and they're trying to adopt rules that override local zoning to the extent that local zoning is exclusionary. We see states like California that have legalized accessory dwelling units, Vermont, which has focused on small scale housing where there's existing sewer service. We see even Utah providing towns with a mandatory array of requirements in zoning where towns have to select from among this menu to show to the state that they are actually advancing fair housing. Of course, as we know, there's no shortage of discrimination in property law. In the video about public accommodations, we discuss federal statutory protection from discrimination in entering certain public or semi-public places. In another video, we discuss the Fair Housing Act and its federal statutory protection of certain people from discrimination in the housing market. In yet another video, we discussed Shelley versus Kramer, which struck down racially restrictive covenants. And that case was about 3 decades, by the way, after the Buchanan case. In many situations, logic, research, and arguments about fairness were not enough to move people to do the right thing. And that is why we have courts and state legislatures that might do better in dealing with exclusionary zoning. We do think that there's going to be a lot more movement in this area in legislatures and courts in the years to come. I'll leave it there. I'd love to hear from you, whether on Twitter or through my website, where you can sign up to my mailing list. See you next time.